All right. I am speaking with Brad Cohen, CNN contributor and criminal defense attorney. We've been following the Casey Anthony case with him and all the different legal issues. Brad is an awesome, fair-balanced guy and a great attorney, and he's been doing a really good job of keeping us, abreast of the legal side of everything in a fair and balanced way. We were able to catch Brad on his way in and out of court today, and we really appreciate him taking the time. There's been so many things happening so fast over the last few days, it's really hard to keep up with. But with Orlando County calling her back within a 72-hour period of time, that puts her having to be back in Orlando tomorrow by 10 a.m., and that literally means calling her back into a line of fire, and we're talking gunfire, because online right now I am witnessing, along with all of the other truth finders, an actual, what we are calling e-lynching of Casey. That's exactly what's going down right now. There are people, and I have seen the conversations that are discussing planning sniper attacks on Casey Anthony. So Orlando is calling her back into the line of fire, even though Judge Strickland has done a double standard. He has expected her to follow the rules when he doesn't. He signs things on a high-profile defendant without reading it. And the Department of Corrections creates orders from that judge on a high-profile defendant without reading his order first. So I don't know what we can do about it now, but let's talk to Brad and see what we can figure out. Tell us about what you are. Hold on one. Okay, we've discussed the issue of probation, but we've had a few developments. So where do we stand with this now, Brad? On the probation?
I believe that the court ordered her back on Thursday to start serving probation on Thursday. Excuse me, and I don't know what the order says, so I have no idea where the judge is going with it in terms of what he ordered originally and where it's going from here. So it's anyone's guess really in regards to what that order says. Only her attorneys know, or someone that pulled the file may know. But I'm sure if it's something that's ambiguous, the attorneys will appeal it.
I know they went in yesterday and they appealed for an emergency injunction, basically. I know that's not the right verbiage. And now I'm hearing this morning that they're still demanding her back tomorrow morning by 10 o'clock.
Yeah, because the judge isn't gonna, if the judge issues her an order to come back, and there's no stay or any kind of form of protective order that's in place, she's got to come back, and then they'll address the probation issue when she gets back to Florida.
And which judge is the one that would be reviewing this emergency motion to stay?
The judge that should be reviewing the motion to stay would be the same judge that would be imposing the order for her to appear. Now, if they filed an emergency appeal, then it would go to the District Court of Appeals, which would be appellate court, for them to either quash whatever order was sent or to stay that order pending some sort of appeal. But nothing's happened yet in terms of her actually getting probation, so I don't think that it's ripe for appeal in terms of appealing the actual order of probation. But they're trying, I guess, to just do an injunction or some sort of stay or a motion to quash, I would imagine, the order to appear before the judge.
Now, online right now, truth finders are following what we're now calling an e-lynching, and these people online, and we're talking thousands and thousands of them right now, are literally trying to plan for snipers to go to Orlando. I mean, real threats. And I just, wonder if there's anything, that people in Orlando could do. What do you know of anything that we can do or that can be done?
I mean, aside from the police, there's not a lot that an individual can do in terms of protecting another individual aside from them throwing themselves in front of a speeding bullet. But it is what it is. There's going to be a crowd there. I'm sure there's going to be crowds that are gathered. I would hope that the police would take the proper precautions and have metal detectors for people that get inside the courthouse, which I imagine they already have in place, and heightened security. I mean, that's the only thing that anyone can do.
Wow. Okay. Well, the only other thing I wanted to get a comment from you about was the issue of them retrying her in federal court.
Right. We touched on this a little bit earlier. They would have to have some kind of federal jurisdiction to try her in federal court. So that would mean cases in federal court generally are of the nature where it involves a federal officer, a post office master, or a postal individual, or FBI, CIA, anything like that. They have jurisdiction over. If they're saying it's a kidnapping case and she crossed state lines, which she didn't, allegedly, then that could have something to do with it. I mean, they would have to figure out some sort of crime that would fit in the jurisdiction of the feds.
Right.
So there's only certain crimes that fit within the jurisdiction of the feds. They always kind of incorporate everything under the umbrella if it affected interstate commerce. So I guess they could try to fathom some way to say that it affected interstate commerce, but I don't see them trying this case federally. But one never knows.
Right, but that does make sense, and that helps ease that concern a little bit.
Mm-hmm.
Okay, well, we just are disturbed that we feel like Judge Strickland's doing a double standard because he's expecting her to follow all the rules and guidelines, yet on a high-profile defendant, he didn't even read the order he signed. And the
Right.
Department of Corrections didn't even read the order that he wanted signed when they created it, so they've made an error. And now they're calling her back into the line of fire, literally.
It seems like everyone made some sort of error. So, I mean, it's going to be appealed no matter what it is. I don't know if she's actually going to start serving probation or they're going to do an immediate appeal on the decision. The problem that they have is that if the original order said for her to start serving probation back then, I don't even know if their appeal is going to be any good because their appellate time might have already run on the original order. If there's a new order that says I'm interpreting the old order to say XYZ, then you can appeal that new order. So it's going to be interesting where it goes from here.
Now, what if they say she has to appear tomorrow and she doesn't because of fear of safety, and then after that it turns out, even if they put a warrant out for her, it turns out that they shouldn't have? I mean, is she going to still be in trouble, or do you know?
Yeah, I mean, the warrant would be for failure to appear for a court order. I mean,
Right.
It doesn't matter if the underlying does anything. I mean,
Okay.
it's if you fail to appear and a court orders you to appear, and even though the underlying is incorrect, you're still ignoring a court order, so you can still.
Right, that's what I was afraid of. All right, well,
Okay.
I appreciate you, and I hope
All right,
you have a
thanks so
blessed
much.
day. Thanks for giving Truth Finders your time. Talk to you soon.
You too, bye-bye.
Bye-bye.